Stanley Tochukwu Okeke v. Linda Amaka Uyanna, Court, High Court of the Federal Capital Territory, Abuja. Quorum, Honor Justice Asmau Akambi Yusuf. Date of judgment, 29th March, 2021. Petitioner, Stanley Tochukwu Okeke. Respondent, Linda Amaka Uyanna. This case concerns a petition for the dissolution of marriage filed by the petitioner, Mr. Stanley Tochukwu Okeke, on the 5th October 2020. The petitioner prayed for the court to dissolve his marriage with the respondent on the ground that it had broken down irretrievably, pursuant to Section 15 of the Matrimonial Causes Act, MCA. The petitioner relied on the facts that the parties had lived for over 2 continuous years immediately preceding the petition. The respondent had behaved in such a way that it was unreasonable for the petitioner to continue cohabitation. The marriage certificate dated 11th March 2017 was admitted as Exhibit A. The petitioner testified as PW1 and adopted his witness statement on oath. Crucially, the respondent did not file a response, lead any evidence, or cross-examine the petitioner. Her counsel also waived their right to defend the matter. Counsel for the petitioner formulated 2 legal issues: whether the petitioner had proved that the marriage had broken down irretrievably, whether the petitioner was entitled to the relief sought. Justice Akambi Yusuf ruled that the unchallenged and uncontroverted evidence of the petitioner, including the absence of cohabitation since February 2018, daily arguments, personality incompatibility, and failed reconciliation efforts were sufficient under Section 15(2)(e) of the MCA to find that the marriage had broken down irretrievably. The court, being reasonably satisfied under Section 82(1) and 2 of the MCA, granted a decree nisi dissolving the marriage to become absolute after 3 months. Who won the case and why? The petitioner, Stanley Tochukwu Okeke, won the case. Reasons: the petition was unchallenged and no defense was raised by the respondent. The evidence presented, especially the fact that the parties had lived apart since February 2018, fell squarely within the statutory ground for dissolution under Section 15(2)(e) of the MCA. The court was reasonably satisfied with the petitioner's narrative, which was legally sufficient to support the claim without further contradiction. The respondent, by her conduct, also acquiesced to the dissolution by not contesting the matter or showing intent to continue the marriage. Further analysis: how could this have been avoided? This dissolution might have been avoided or at least delayed with the following measures: premarital counseling and compatibility assessment. The evidence indicates that the parties discovered deep-seated personality incompatibilities only after marriage. A structured premarital counseling process might have surfaced these issues earlier. Conflict resolution mechanisms, daily arguments, and poor anger management were cited. Professional intervention through marriage counseling or conflict resolution therapy may have helped reduce tensions and promote understanding. Family mediation. Although family members attempted to mediate, the judgment suggests these efforts were unstructured. A formal family mediation session with a neutral facilitator could have had better success. Communication breakdowns. The respondent left the matrimonial home without the petitioner's knowledge or consent, indicating severe breakdown in communication. Rebuilding trust and open dialogue channels could have offered reconciliation prospects. Legal advice early on. Both parties might have benefited from early legal advice, especially regarding their rights and responsibilities under the Matrimonial Causes Act. A clear understanding might have prevented escalated conflict and sudden separation. Conclusion: the case reflects the Nigerian judiciary's structured and evidence-based approach to matrimonial disputes, particularly under the Matrimonial Causes Act. It also serves as a reminder that unresolved domestic issues, if left to fester, may ultimately result in legal dissolution, sometimes unopposed, if one party disengages entirely from the marriage and judicial process.